So I guess we're going to get started. And so the topic of this talk, of course, is the Jack Daniels litigation. And to disclose all my biases up front, the graphic I have is one of those, handy AIs. A bottle of whiskey comes to life and demands that people respect the power of its trademark. And this is what whichever engine I was using spat out for me when I asked for that. So let me give an outline of how this is going to go. I'm going to just sort of talk very briefly about the course of the litigation up to this point, how we got to the Supreme Court. And then I'm going to focus most of my talk talking about the oral argument that was held a few weeks ago and the kinds of tensions it reveals with respect to trademark law. Because I think it was very interesting because of course, none of the justices or are experts on trademark law. They don't focus on it. And so it's kind of interesting to hear them work through in real time some of the very real issues that are raised by the Jack Daniels case. So the case arose when the company Silly Squeakers made a dog chew toy, and it's obviously evocative of the Jack Daniels trade dress. So rather than being called Jack Daniels, it's called Bad Spaniels. Rather than the old number 7, it's the old number 2, 43% alcohol by volume versus 43% poo by volume, and 100% smelly, right? So we have poop jokes. Jack Daniels didn't care for the nature of the joke being made, and we have litigation. And in that litigation, Jack Daniels wins initially before the district court. So Jack Daniels has 2 claims. One is for infringement of the Jack Daniels mark and trade dress, saying that there is a likelihood of confusion between the 2 products, right? And so the statutory standards for likelihood of confusion, section 32, a use that is likely to cause confusion or to cause mistake or deceive. Section 43A, use that is likely to cause confusion as to the origin, sponsorship, or approval of the goods. Jack Daniels also brings a dilution claim for the tarnishment of its famous mark. And the statutory definition of tarnishment is an association between a mark and a famous mark that harms the reputation of the famous mark. And in a bench trial, Jack Daniels wins on both claims. There is a likelihood of confusion as to the source, affiliation, or authorization/approval of the chew toy by Jack Daniels. And in addition to that, associations with poop are going to cause tarnishment that harms the reputation, or is likely to harm the reputation of the famous Jack Daniels mark. As you may expect, Silly Squeakers brings an appeal to the Ninth Circuit. The Ninth Circuit reverses the dilution ruling based on a statutory carve-out in the dilution statute for so-called non-commercial uses, saying that the speech is non-commercial if it does more than propose a commercial transaction. This is more than an advertisement, more than just a trademark. It was expressive. Therefore, it falls under the carve-out in the dilution statute. And it vacates the finding with respect to trademark infringement because the district court failed to apply what is the leading test for dealing with expressive uses of trademark, the test announced by Rogers versus Grimaldi in the Second Circuit, and now widely used throughout the nation in situations when we are dealing with so-called artistic or expressive uses. And so the case came from a case involving the movie by Fellini, Ginger and Fred. Ginger Rogers didn't like that. She brought trademark infringement and right of publicity claims. That's where the test comes from. And there's a 2-part test for expressive/artistic uses of someone else's trademark. Number 1, is the use artistically relevant? If the answer to that question is yes, we ask, does the party who used the mark do anything that explicitly misleads consumers as to the source or content of the work? So the case goes back down to the district court. Oh, I'm sorry. And I just want to give you some sample uses of the Rogers test over the years. Some of you may know the Barbie Girl song. I'm a Barbie girl in a Barbie world, life in plastic. It's fantastic. Mattel, the holders of the Barbie trademark, did not like that. and they brought trademark infringement litigation, and application of the Rogers test insulated the Barbie Girl song from trademark from trademark liability. Likewise, a couple of years ago, somebody is in the business of painting famous scenes from the history of Alabama football and Alabama college football. The University of Alabama claimed that paintings like this violate its trademarks because they have a trademark in the crimson uniforms, and that there might be some kind of confusion of affiliation or the like. The 11th Circuit says, no, we apply the Rogers test. People have a right to depict Alabama football in painting and other kinds of art. So that's kind of a traditional application of the Rogers test. And in applying Rogers on remand, the district court says, all right, if I got to apply Rogers, then the defendant wins. The use of the Jack Daniels trade dress is relevant to the joke that's being made, right? A poop joke about Jack Daniels. And there's nothing more done by the defendant to suggest a connection with Jack Daniels. They have their own trademark. They display many affiliation. It's small, but there's nothing more there. And so, alas, I have to follow the 9th Circuit rule on Rogers. And I'm not adding in the alas. The district court actually said something along these lines. This is terrible. I mean, it didn't say this is terrible, but the district court said, Jack Daniels has no means to protect the viability of its trademark. Yet I'm bound. What can I do? The 9th Circuit is making me live with this poop joke, right? And so for Jack Daniels or similarly situated trademark holders to get a different result, they've got to seek relief before the Supreme Court, and that's what happens. There's a summary affirmance by the 9th Circuit. Jack Daniels files for cert on both the dilution and the Rogers question. The Supreme Court grants cert on both. A terrible thing that's going on in this case is that you have two really important, interesting trademark questions, and everyone's only paying attention to the Rogers one because it's so big. I am going to continue that problem, and I'm only going to focus on the trademark side, trademark infringement side of things, and not focus on the dilution questions because of time constraints. So, oral argument was held on March 22nd, and I see 7 interesting issues as emerging from that exchange between the lawyers. I mean, there's many more, but these are the ones that I have on my little outline. Why this case? How do we stop trademark from reaching too far? What is the role of fact-finding versus judicial intuition and normative choices in adjudicating trademark claims? When we say confusion is key to trademark infringement, what do we mean by confusion? The tension between trademark liability and trademark defenses, the role of merchandising in trademark law, and generally the power of brands. And we'll see how far this outline I actually get through. So, number 1, why this case? So the Rogers test has been around in some form over 30 years, and it is by far the leading approach of the lower courts in handling questions where somebody is using somebody else's mark in an expressive manner. Not every court of appeals has adopted the test, but every court of appeals to consider the question to actually litigate it out has adopted some version of Rogers, and many district courts have as well. But again, not every court of appeals has actually said, yes, we bless Rogers, but it is the rule in the 2nd Circuit and the 9th Circuit. So of course, the rule that governs in the leading entertainment centers in this country of New York and Hollywood. So given that, why now? Why does the Supreme Court decide to act here? What's the difference between the chew toy and something like Barbie Girl? And I think the answer is pretty clear when we hear Justice Kagan's questioning of the VIP's attorney. And now let's see if it actually works.
So, I mean, whether the Rogers test gets the question exactly right, whether there should be a better test to think about First Amendment issues, you're sort of out of that. I think you're sort of leagues away from that. This is a standard commercial product. This is not a political T-shirt. It's not a film. It's not an artistic photograph. It's nothing of those things. It's a standard commercial product. I don't see the parody, but, whatever. You're using this, as your complaint says, as your registration on the other product say, as the placement of your hang tag says. You're using it as a source identifier. It seems like just not a First Amendment Rogers kind of case. And the First Amendment Rogers kind of case, I think what this argument suggests is those are hard questions. I guess the question is, why aren't you leagues from Rogers?
I will agree with Jack Daniels' counsel on one thing. The distinction between utilitarian goods and expressive works is a non-existent standard. Your Honor gave as an example a T-shirt. T-shirt, people buy them in order to not get caught up with public nudity. They are functional utilitarian goods, but they may also bear a message. Whether it's a hat or a hat, we all know can become political symbols, or a T-shirt or a coffee mug.
Okay, a dog toy, I'm just going to say, is a utilitarian good. Yeah,
Well,
there might be some hard cases. I actually don't think that the political T-shirt is a very hard case. It says something, it's making a point. But dog toys are just utilitarian goods, and you're using somebody else's mark as a source identifier, and that's not a First Amendment problem.
And if we, Your Honor, if we changed the hypothetical and we said, okay, put on the hang tag, not for use with real dogs, and it was sold purely as a collectible, because that's what the testimony was, that they intended that this was in part be a collectible from the graphic designer who worked it up. Then it would not be a utilitarian good, it would be soft sculpture in copyright terms, and it would be an art piece. It doesn't matter whether you use it with your dog or you put it on a shelf, as I plan to do, and laugh at it from time to time. It is still an expression. And what Jack Daniels is upset about is not the utilitarian good. They're upset about the speech that's born on it.
Okay, so this is a really interesting exchange, and I think it gets to why cert gets granted here for a Rogers case when none has been done before, right? This just isn't worth First Amendment protection, at least from a certain point of view, right? The idea that other uses that the court is thinking about, what happens if we go too far, they involve art, they involve political commentary, they involve something more than a mere consumer product. This is not a song, this is not a movie, this is not a political T-shirt, this is just a chew toy. And Kagan makes the point of saying, I don't see the parody here, right? And so the idea that maybe if you're claiming expressive uses, if you're claiming a defense like Rogers, right, you need to have some kind of justification that goes beyond having a mere commercial product. And so I think some of the underlying premises to that question, some of which I may talk about more as we go along, is this idea that when you're dealing with a mere commercial product and a mere piece of merchandise, a dog chew toy that evokes Jack Daniels, that is a market that just by its very nature belongs to trademark holders. There's the kind of market that's very much like the Chicago Cubs baseball cap, and that the Chicago Cubs control that market, even though the C is not acting as a source identifier for who made the cap. And so what I think is going on in this exchange is that this is something that's closer to the Chicago Cubs baseball cap. And maybe there are some uses that might need protection, because they're justified in some way. They're more than a mere commercial product. They do something more, but this ain't it. And I don't think that's a coherent statement from a trademark perspective, but I think it's a very natural human reaction to the situation. And I know that when I talk to people about this case, that's people's snap judgment a lot of times. Like, why is somebody using the Jack Daniels mark without their permission? That just seems wrong. And I think that there's that kind of same, visceral reaction on the part of a lot of the justices on the court, or at least that's my speculation as to why this is the case that gets a cert grant after all these years. But as you see in the response by Jack Daniels' by VIP's attorney to Justice Kagan, right? It's quite questionable whether a commercial product line is even remotely coherent. And so he makes the point that, a T-shirt which is sort of the baseline the court is working for, is something that may implicate the First Amendment. Well, it's purely functional too. It's a consumer product. It keeps you warm. Not that warm, but it enables you to cover yourself in public settings. It's entirely utilitarian. It's a commercial product. And likewise, this may be seen as a mere commercial product, but what if I put it up on my wall, right? What if I have it on display? What if I just keep it around as something to appreciate, like a soft sculpture, right? And if we're able to make that blurring of the line, then we should consider the expressive qualities. But I think where the court is, at least as a visceral matter, is that this is a mere commercial product. This is not the kind of thing that drove courts to create something like the Rogers test in the first place. The reason why courts developed something like the Rogers test in the first place is to stop trademark law from reaching too far into those areas where judges have a reverse visceral reaction. This idea that says, surely this is not the kind of thing that trademark law can be used to shut down or to censor. And that we now get the line drawing problem on the Jack Daniels side, right? If they win, how are they going to stop trademark law from being used to police things that the court has a visceral reaction ought not to be policed? And this comes out very starkly in an exchange between Justice Sotomayor and the attorney for Jack Daniels, where she basically is asking, how are we going to protect more clearly expressive speech? Can we avoid making trademark defendants from going through the whole rigmarole of an infringement suit, going through the possibly having to commission a survey, which is expensive, possibly having to march through the multi-factor test, which is a very, is a legal structure that kind of guides the path of trademark litigation. And you'll hear reference to the Polaroid test. That's the name of the multi-factor test in the Second Circuit. It's Sleekcraft in the Ninth Circuit, which is where this case came from. And so is it possible also, Sotomayor is interested in, can we vindicate speech interests, even if something may seem like it causes a likelihood of confusion under the terms of the Lanham Act? So this is going to be a fairly long excerpt, but it covers a lot of really interesting ground. So I'm going to
assume
and
that
she
I
starts with the
think
hypothetical.
that there are some uses that in context on their face should not require a litany of Polaroid factors with surveys and everything else for a court to be able to decide this on a motion to dismiss or summary judgment. An activist takes a political party's trademark, Animal Logan.
I'm sorry, I missed that last part.
Takes a Animal Logan, a donkey or an elephant, okay?
Oh, elephant.
Yeah, whatever.
I got it.
One of the political party's Animal Logans, and makes a T-shirt where the animal looks drunk, accompanied by a slogan, "Time to sober up, America." And they wear that proudly at a protest or here in court.
Do you want my answer?
She sells these T-shirts on Amazon.
Okay.
The political party gets a consumer survey purportedly showing that 15%, 20, 25, 10, whatever number we make up, okay, think the activist needs the party's permission to copy the logo. So, I'm a judge. I know what I would do. But tell me what you would do. And do they have to go through a full trial under the Polaroid factors to decide this case?
Okay, so, first of all, that's funny. Your example, going to give you that. Second of all, if I could go back to the point about Polaroid, there is the fact that a product, including your T-shirt example, is funny or it has a parody is not relevant. What is extremely relevant is any characteristic.
Is whether the person viewing it would get the joke.
No.
And so isn't that the issue that we're dealing with in confusion?
Well, I'd like to get this answer out. It's not whether you get the joke. You get that somebody other than the brand wasn't making the joke, because that's all that matters. Not ha 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 is not a standard under the Lanham Act. It's whether it's confusing as to source. Now, in your Republican, elephant
well, that's
example,
going back to Justice Jackson's point, and you said it's not only about source. So what else is it about?
Right. Okay. On your elephant example, in terms of if there's a mistaken idea that, oh, well, you had to copy. Okay. First of all, on consumer surveys, they're capturing, for whatever reason, because consumers are dumb or they're confused about the law or just the way they make marketing decisions, surveys are picking up the real world marketplace that a judge who has hindsight bias and is highly analytical is not going to represent the purchasing public. The reason we have surveys in the first place is pretty amazing. In 1948, Jerome Frank on the Second Circuit had a case involving teenage girls' underwear, and he said, you got to be kidding me. I'm a man. Everyone on this court is a man. How am I supposed to know this? Couldn't somebody do a survey? And surveys were born. And that was in 1948. So it's just a little bit rich to trash surveys when the whole point that they came out was to help consumers. Now, on that bit about there's a mistaken perception, it's not a mistaken perception. You do have to get permission if it's confusing. Now, your example on the T-shirts, if there's a survey on 15%, and I also heard in there some sort of implicit thing that 15% was too low. If this court had a rule saying, advocates, please do not have briefs that are likely misleading, and if you want us to say, advocates, that can go up to 50%, because it's okay if only 20% of judges found it deceptive, or even 40%. It has to be more than half. So I think what you're...
But that's the basic problem, which is the percentage. At some point, it's a political statement. It has First Amendment rights. And even if 20, maybe even if 75, it's very clear that at a certain point, those people may be wrong on the law. They don't need permission to make a political joke. They don't need permission to make a parody.
You need to get permission if it's a confusing parody.
Okay, like I said, there's a ton in that exchange. I want to, I could spend a whole hour on that exchange. But the core question, right, is what do we do when the trademark use potentially implicates what we would call, quote unquote, core First Amendment speech, core First Amendment expression? And I want to say, I understand that there are views of the First Amendment that say, it's all core, right? And the First Amendment, reaches a lot of stuff, even if it doesn't touch on political speech. And I get that, right? I'm not arguing that point. I'm just saying that this is where the question is coming from. Let's start from the thing that we all agree, Sotomayor says, has to be protected, right? You use somebody's logo in order to make a political statement. What do we do in that situation? And so this is, again, the inverse of the line drawing problem that Justice Kagan was asking VIP's counsel. And so Sotomayor is saying, look, not only am I concerned that we protect this kind of speech, but I want to make sure, or what I'm asking you, is how do we deal with this at an early stage? It's not going to do the political activist any good if they prevail on a likelihood of confusion claim after having to commission a survey, after hiring lawyers who have to march through all of the Polaroid factors, et cetera, et cetera. I want to know, how can we dispose of this stuff at an early stage without having the expense of a trial? So Sotomayor's assumptions, right, about, and again, this is me using AI. I'm not taking it actually. I asked Dolly to give me a drunk elephant or something like that. So her underlying assumptions is, number one, this is not confusing in the first place. But number two, and it comes out later in the exchange, even if it were, it should not be the subject of a trademark infringement claim. And so what do you say about that? And so the response from Jack Daniels' lawyer is pretty robustly in favor of really far-reaching trademark rights. And so it doesn't matter if it's a joke. It doesn't matter if people get the joke. What matters is whether there's confusion. And of course, that's begging the question that I want to talk about in due course as to what do we mean when we say confusion? Confusion of what? And then we have this exchange about the role of surveys. And there was a survey in this case, and it was a survey that purported to show that 29% of respondents, when presented with a sample and a control, that had some kind of confusion about the relationship between Jack Daniels and the chew toy. Various kinds of confusion were under the portals of the survey. I'll talk about that in a few minutes, but I just want to say there was a survey in this case. And so Sotomayor, right, as one of the tenors of her question, is that people will say, well, there's a danger that, if you find the right expert, you can get a survey that can, point for confusion in a variety of directions, even when it may be something like this that we don't think ought to be policed under trademark law. Blatt's response is to say surveys are awesome, right? Surveys are awesome because it allows judges to figure out what consumers on the ground are potentially thinking. Now, that's a debatable point about how accurate surveys actually are. But then there's this very elitist defense, right? Oh, you judges, right? You're so smart. You're so analytical. But we need something that can capture what really goes on in the market. The possibility that consumers are stupid, I think she actually used that, or dumb, or something along those lines, right? And this is somehow protective of consumers, but it kind of raises the question of, well, what's the protection given to consumers by removing something like the chew toy off of the market? But sort of and then the other point she makes is that, look, even very low levels of confusion on a survey, like 15%, gosh, that's really significant. That's a lot of people who may potentially be confused. But Sotomayor responds that, like, no, that's a normative choice, right? When you're deciding how much confusion on a survey matters, you're making a choice. There's nothing in the Lanham Act that tells you what percentage response you should get on a survey. And everybody understands that at a certain very low level, things are just background noise, right? But then where you set the threshold as to what counts, it's a choice. And it's a choice that courts make in practice. And so Sotomayor's point is that regardless of where we set that level, it just shouldn't matter when we get to something like the hypothetical Wake Up America t-shirt. And so what happens when push comes to shove? Sotomayor says, for some protected speech, you don't need permission, period, right? And Blatt says, wrong. You need to get permission if it's a confusing parody. So when push comes to shove, Jack Daniels' lawyer is saying, no, no, no. If it's illegal under the Lanham Act, then it doesn't matter if it's a parody or not. And so this is, I mean, I'm not scoring at home, right? But listening to this didn't seem like it was a good exchange for Jack Daniels, or at least in terms of responding to the concerns of Justice Sotomayor. Okay, so this kind of brings me to the next point, right? That Sotomayor has this perspective in talking about the hypothetical t-shirt, saying that, look, this is just not confusing, period. And can we do that? Can we do that without fact-finding? And those of you who are in my trademark class now know I am sometimes interested in this question and all the various ways courts sometimes do wave their hands and make normative choices without explicitly fact-finding. And part of it is this idea of how do we normatively define the consumer? And so I don't have the audio clip of this, but I have an exchange on the text between Justice Alito and Jack Daniels' attorney. And he comes at it from the perspective of saying, well, wait a minute. Isn't the very premise of why we're here a little bit off? Is anyone actually going to be confused between the Jack Daniels chew toy, between the Bad Spaniels chew toy and Jack Daniels whiskey? And Alito asks, could any reasonable person think that Jack Daniels had approved this use of the mark? And Blatt says, absolutely. That's why we won before, right? We had a whole party and everything, right? And so Alito pushes some more and says, well, wait a minute. Like the toy doesn't say Jack Daniels on it. And I cannot believe for a second that if the actual Jack Daniels company had a mind to market chew toys, that they would do so obliquely, right? They would just put the Jack Daniels mark on it, right? And no reasonable person would think, when they see someone else doing a parody type thing, that that's actually Jack Daniels. And, Blatt pushes back and said, Justice Alito, I don't know how old you are or where you went to law school. You're very smart. You're analytical. Oh, you're so smart, Justice. Okay, so many comments are coming to mind that I won't make now. Okay, it's just a little rich for people who are at your level to say what the average person purchasing public thinks about. Dog toys you might not know anything about. And so I think, and he says, well, I don't know, I've had dogs, but, and this is, I have to concede a good point on his part, the question is not what the average person would think, it's whether this should be an acceptable conclusion under a reasonable person standard, right? So the idea in common trademark cases is that we're not just asking are people likely to be confused, but rather reasonable consumers exercising ordinary care. right? And that the possibility is that when you deal with survey results, you're not necessarily having consumers with a stake in it, right? Making things with decisions with the kind of attention we would expect them to exercise in the case of the marketplace, or at least that's a common criticism of the use of trademark surveys. And so we have this other thread going on here about what it means to fact find in these cases, and to what extent can we make normative judgments, and to what extent can we make those normative judgments explicit. And this is an ongoing undercurrent problem of trademark law, because if you read cases about what courts say they are doing, they tend to generally say, we're just finding facts, and this is not for us to second guess what consumers may or may not think. Okay, next point. I've foreshadowed this one before, and this, I think, is really a fundamental question in this case, right? We're talking about likelihood of confusion, but confusion about what? What kinds of confusion are sufficient to give rise to liability under the Lanham Act? And so this is kind of Justice Alito's question in the first place. How did we get here? How is this a trademark claim in the first place, right? And so one, kind of like the core, the heartland, the kind of thing that everybody agrees is actionable trademark infringement, is when we have a likelihood of confusion about source. Do people think when they see the Bad Spaniels chew toy, will they think that the source is the same source as the whiskey they may enjoy at various points on the weekend? In addition to that, the statute makes reference to likelihood of confusion about sponsorship, and most troublingly, likelihood of confusion about, quote, approval. And so what does approval mean? Now, if it means in some way standing behind a product, then we can probably tell some consumer protection stories about why that matters. But if we're just talking about giving permission, I have a mark, I have absolute power over it. And if you use my mark without my permission, people might think I gave you my permission. And that should be the basis of a federal case. And so the court hears this concern, and it's the subject of an exchange between the court and the Solicitor General's office, right? And then we can, but just back up, we can also question whether any of these or which of these should actually matter to consumers, right? If we're talking about source confusion, I buy a Coke, I want to buy a Coke, someone gives me a counterfeit Coke, I spit it out, I feel bad, right? That harms Coca-Cola, but it also harms me, right? Coca-Cola's interest in policing its mark in that space is also protecting me in some way. We can tell a story that harmonizes the interest between me and the trademark holder. But can we tell a story in all of these cases? And so this comes out in, the problem of permission confusion comes out in this exchange between Justice Alito, then later joined by Justice Kagan, and the attorney from the Solicitor General's office. And so the exchange begins when Alito asks if public perception that public perception that, I said confusion there, I meant to write permission, my bad typo, is the public perception that permission is required. Is that something that should count towards a likelihood of confusion analysis, right? So that's how the question begins.
And what about the fact that a lot of people surveyed may think that as a matter of law, it was necessary to get the approval of the mark holder?
Well, that's a hard case. That's a hard question. There are, certainly some amici supporting respondent who say that that's a kind of legal mistake that should just be dismissed in the likelihood of confusion analysis. I think that's hard to say because the Lanham Act itself, one theory of trademark infringement is that consumers are confused about whether the mark holder has granted its permission to use its marks. That is, whether it has granted legal permission to the allegedly infringing junior mark. If the surveyed consumers think, yeah, you couldn't do this without getting Jack Daniel's permission, I think that's evidence of likelihood of confusion. Now, I will say, just to step back a second, surveys are just, it's one piece of the puzzle here, but it's not the whole thing. They are meant to be an approximation of consumer perceptions in the marketplace.
The point is that these surveys are expensive, and they're in a test that is a multi-factor test, which is confusing, which doesn't provide a lot of guidance in particular situations. It's an extremely kind of expensive litigation to go through. So when you look at these hypotheticals that were given to you, whether they're political or whether they're artistic speech, and your first line defense of this, and as I conceive it, your second and third line defense too, is don't worry, you'll win on likelihood of confusion. I think that what this Rogers test is all about is to say that there are some things, the political hypotheticals, the artistic speech hypotheticals, that shouldn't have to go through this whole analysis, and that we can get rid of in the first instance on a motion to dismiss without surveys, without a lot of fuss and bother.
So Justice Kagan returns to the point we talked about before, about whether there's something we can do at the front end of the litigation that is going to be protective of speech without making the parties march through all the costs of litigation. But prior to that moment, the SG's lawyer bites the bullet, right? Basically says, if you look at the text of the Lanham Act, yeah, I guess it's true. I guess it's the case that confusion about whether permission was granted is enough to sustain a cause of action. And that is, as there's a reference made to amicus briefs. I didn't write it, but I joined this one. I think it was this one, saying that it should not be a likelihood of confusion if it's based on a legal analysis. Because the question about permission, right, is whether or not permission was required. And if you think permission was required, then you might be confused about whether or not somebody gave their permission when you see something being used. But where does the perception that permission is required come from? It's going to be a lot stronger if Jack Daniels wins this case, right? It's something that is a byproduct of what courts do. And so it's just a fascinating exchange. He's asked directly, can confusion about permission be enough to sustain a claim? Yeah, that's a hard case, but I guess so. And so anyway, I found it to be a fascinating moment. And of course, as I said before, a win by Jack Daniels is going to feed that perception. But then it raises another question, right? And this is the one I meant to have as a separate point, but now I'm just having it in the course of talking about the last one. Why should trademark law care? Why should trademark law care if I am confused about whether or not somebody could make a dog toy that is not a pure reproduction of Jack Daniels' mark without getting their permission? And the problem or the underlying tension with trademark law that gives rise to my even asking this question is the question comes from a place of why do I care? And so is this material to me as a consumer? But trademark law does not have a materiality requirement. False advertising law has a materiality requirement, but it doesn't exist in trademark law. Now, in the old days of trademark and unfair competition, where the cause of action was pretty much limited to passing off at the point of sale, there's no need for a materiality requirement, right? We understand that if I ask for a Coke and somebody hands me something that they brewed in their bathtub, I'm harmed in a particular way, right? That's meaningful for me. I asked for the Coke. I thought I was getting a Coke, and I didn't. But if we start moving afield of point of sale source confusion to theories of permission confusion, well, then I think it's worth asking questions about whether or not that's something that matters to consumers. And I don't want to overstate the case here. If you delve into the literature, there are people who argue that consumers actually do care, and we can debate that. The point is that there is no actual such requirement in the law as an element of the cause of action. The other interesting thing about permission confusion is that whether you agree with me or not, that it's not particularly material to consumers, I hope maybe we can agree that it's less harmful to consumers than source confusion, that the idea of asking for a Coke and getting something else has more immediate risk to me than if I think Coca-Cola sponsored, approved the T-shirt that has, a parody of Coca-Cola products on it. But if that's so, why is it easier to prove claims like this? And what do I mean? I mean that if Bad Spaniels had dressed up its mark the way it had and actually was selling bottles of whiskey, and Jack Daniels brought a pure source confusion claim, I'd be very surprised if Jack Daniels could have prevailed, right? Because a big part of this case is not source confusion, it's this permission confusion. And I said I'd come to the surveys in due course, and so here I am. So a big part of the district court's ruling in favor of Jack Daniels was that there was a survey, and the survey showed 29% confusion on the part of survey respondents. And in ruling in Jack Daniels' favor, there was no disaggregation of that result, no examination of the result. What happened in the actual litigation was VIP had an expert of their own, but what the expert for VIP did was basically attack the plaintiff's survey, but didn't have a survey of its own. And the court was like, all you did was attack Jack Daniels' survey, you didn't have anything of your own. I find this number really quite impressive. And so one thing the VIP expert did do was look at the component parts of that 29% by looking at the actual answers of some of the survey respondents. And he concluded that when we talk about the source confusion among them, it was only 11.8% of that total figure. So if you're of a mind, and again, you may not be, you intuitively, one may have a strong feeling that this kinds of approval claims are very important. And, but if you don't, right, then it's worth noting that that's what normal trademark cases would consider to be a fairly low response when it comes to a survey. Usually you have to at least be 15 to 20% or something along those lines. And of course, this bespeaks a lot of larger issues in trademark law about how surveys are designed and used, whether or not you can measure materiality to consumers, whether or not you would consider the depth of uncertainty, right? You show somebody a chew toy and say, do you think Jack Daniels is, approve this? Yeah, sure, I guess. But how confused are you? Do you care? If you care, do you check? Right? And this is the thing about whether consumers do on surveys the kinds of things they would do in the marketplace. There's a really good law review article that was just published by Barton Beebe and several colleagues, and I'm not going to remember, I don't remember all their names off the top of my head, that actually began some experiments with consumer surveys where instead of just saying, who do you think is behind this? They started giving like Likert scale certainty measures. And it's like, who do you think is behind this? How certain are you? And finding that there's actually, a lot to be said there about the level of uncertainty. And then in many cases, they were duplicating results of surveys that are in certain famous trademark cases, but finding that people in the survey responses, while on the side of more likely than not sponsored or whatever, reflect a lack of certainty. Right, and the kind of certainty that is perhaps not likely to be guiding purchasing decisions, or at least that's the argument. It's an interesting article, so it's worth a read. Emory Law Review. Okay, and so this is back to the recurring question I talked about before: is likelihood of confusion just a fact question, or given the openness of the statutory test, likelihood of confusion, right? Is it a normative one? Because you have to answer questions about what kind of confusion, when do we measure it, confusion of whom, how much evidence do we need, how do we treat surveys, how do we structure the inquiry in general, right? The point of Jack Daniels is saying that, what we really have to be doing is we shouldn't have this nonsense about Rogers. We should just have our ordinary multi-factor likelihood of confusion test. And I can't remember which justice pointed it out, but the multi-factor likelihood of confusion test is a judicial invention. It was made up by, associated with the Polaroid case, famous opinion by Judge Friendly, and it was adopted by other courts across the country. But there's nothing in the statute that says, here are the factors. This is how you structure trademark infringement litigation. It's something the courts came up with, just as was the case with Rogers. And this leads me to the next interesting tension on display in the oral argument. So, as I've been saying, likelihood of confusion. That's a very vague, potentially quite broad term. It's open to a lot of judicial interpretation, and it's interpretation that can read trademark rights as being quite expansive. That language is not counterbalanced in the Lanham Act by similarly broad defensive language, similarly broad language that says these are the kinds of things that are not trademark infringement. There is stuff there, but it's not similarly open to judicial interpretation, I would say, in the manner that likelihood of confusion is. There's nothing on par, for those of you who've studied or practiced copyright law, There's nothing in the Lanham Act that is on par with the fair use doctrine of copyright. And so the problem with that is that creates a potential mismatch, that you can have courts moving the scope of what might be subject to liability under the Lanham Act to encompass a broad range of activity, but you don't have the same kind of common law flexibility of courts to curtail things back, to carve things out and say, this kind of activity is not infringement. And so this comes out in an exchange between Justice Jackson and the Attorney Black, right? She points out that from a certain point of view, the defendant isn't using the mark to designate source, right? This is not really a trademark use. This is just sort of the joke. And we're not asking people to buy it because the person behind this is behind the chew toy. We're asking people to buy it because this is the joke. This is the funny thing. We want you to buy the funny picture on the dog toy. And so Justice Jackson is saying, like, well, wait a minute, maybe we should be able to dispose of this case on the front end because this isn't even a trademark use in the first place. And so maybe that should be the way we dispense with cases like this at the front end. And here's the exchange.
But I wonder whether the cleaner, more sort of consistent with the statute way of looking at it is to ask, is the artist using this mark as a source identifier, as the threshold? And if they aren't, then I guess the Lanham Act doesn't apply because, as you've said, the Lanham Act worries about confusion that arises from use of a mark as a source identifier. So if they're not doing that, then there's no trademark problem. But if they are doing that, if it's being used as a source identifier, then I suppose we get into all of the questions under the Lanham Act test as to whether or not there's trademark infringement. What's wrong with that?
Well, unfortunately, a lot. And with respect, that literally you're taking language in the text of parody and in the text of 1115b4, which you had a Supreme Court case on, KP permanent makeup, saying other designation of a source are actually exceptions under two statutory provisions that don't appear in infringement. So I'm fine with you making up stuff.
No, but I'm not making it up. I mean, you said here this morning, and I wrote it down, that the whole confusion issue. Do you agree that confusion is the heart of the Lanham Act?
Confusion has nothing to do with designation of source.
Okay, so yeah, in hearing that first time, and I'm not the only one, you're not the only one, I found it very jarring, the response, you know, I'm fine with you making stuff up, right? I mean, it was, yeah. The general point, though, right, that she's making, right, is a defensible textualist argument, if you go for that kind of thing, that says there are certain specific carve-outs in the statute, expressio unius ex exclusive, you know, right, that's as far as it goes, and you cannot just go ahead and bring in other considerations. Now, it is not the case that there is no textual basis for arguing a trademark use requirement, but that's a different lecture, a longer discussion for another day, but that's the conflict. Regardless of whether there's room to argue trademark use as a requirement, it actually is the case that the liability conferring provisions are broader than the liability carve-out provisions. And so that the tension faced in trademark law and on display in this exchange is a very real, very significant one in trademark law. If you do think that trademark law has expanded its reach a little bit beyond what is necessary for consumer protection, obviously if you don't think that, then it's not a similar kind of problem. And so the response by Jack Daniels, right, is there's no trademark use requirement in the statute by this text, and that's that. And a similar claim, because it undergirds their case, right, that there is no similar room for Rogers. There's nothing in the Lanham Act that allows an artistic relevance test, right? And so all that really matters is whether consumers are confused. Those poor consumers, right, who she called, you know, not being very smart. All that matters is preventing their conclusion, though the heavens may fall. But as, again, Justice Alito pointed out somewhat, the First Amendment is a text too. And so why can't we read the broad text of the Lanham Act?
Isn't your argument that anything that so long as something is protected by the Lanham Act, there is no First Amendment issue?
Well, when you say, yeah, I think that unless you're going to bring it as applied, you have to, yeah. I mean, it's confusing speech, and it goes to the dilution. But yes, I think the Lanham Act is clearly constitutional. You all but held that in the San Francisco case.
No, the question isn't whether it's constitutional. The question is whether it should be interpreted, and this is where Rogers may come from, in a way that does not bring it into conflict with the First Amendment.
Well, then you should strike the statute as either facially invalid or as applied to a dog toy. It just seems that you're overturning centuries and billions of dollars of brand investment as to confusing.
Okay, so what's the role of the First Amendment in interpreting the Lanham Act, right? Now, obviously, Rogers comes from a felt need to accommodate First Amendment considerations, and the side arguing that Jack Daniels has no place in the law is going to say it's all or nothing. The Lanham Act is fine under a First Amendment perspective, and the only way to say the First Amendment applies here is to strike the whole thing down or have some kind of special First Amendment test for, in an as applied situation. So the basic idea here is like, if we get the First Amendment and it all falls down, so we can't do that, right? So we can't, nothing to see here. Now, the normal view of the First Amendment and the Lanham Act, or in trademark law, is that there is no First Amendment protection for engaging in fraud. If you want a Coca-Cola, I sell you a Coca-Cola, I give you something other than Coca-Cola, I've committed a form of fraud. And it's never been the case that that kind of exchange was viewed as being subject to the First Amendment. When you come at trademark law from that point of view, of course there's no trademark problem with the First Amendment. The problem comes in when you start having more expansive trademark causes of action. And, the Jack Daniels attorney is saying, gosh, we're going to throw years, centuries, billions of dollars of investment. Well, it's a relatively recent innovation for trademark law to be read quite as expansively as it is today. And the contra view, of course, is that the text of the Lanham Act is fairly open. So why shouldn't we interpret it in light of other considerations, such as the First Amendment? Next point. Let's get to this billions of dollars point. We're almost at the end, right? Billions of dollars and the role of merchandising. And Justice Kagan's comment before, this is just a commercial product. I think what's really going on in this case, or why we're here, is that, again, there's this strong intuition that says the Chicago Cubs get to control the market for baseball caps. And when you look at that question, when you look at it from the perspective of what trademark law is for, it doesn't make any sense as a matter of trademark law. Because nobody buys a Chicago Cubs baseball cap because they think the Chicago Cubs make a great baseball cap. They buy it because they want to show their affiliation with affection for the team. You don't need the Cubs to approve the sales of their caps for that purpose. But people have a strong intuition that says the people who created that value is the Chicago Cubs. And if I stitch a Chicago Cubs baseball cap in my basement and I sell it to you, I am free riding off of that work. And every year, I ask my trademark class at the beginning of the year a bunch of hypothetical questions about what trademark holders should or should not be able to do. And one of them is this question about merchandising. And every year it's like 100%, 90%, 95%, something like that in favor. Oh, of course, the holder of the McDonald's mark should be able to control its use on a t-shirt. And after the course of the term, when they hear my, left-wing ranting about how trademark law goes too far, I always, survey them again, and same results. I change maybe one mind in the course of a semester. That's fine. That's fine. Intuitions are resistant to argumentation, and maybe I'm wrong, right? I'm weird in a variety of ways. The point is that there's a strong intuition, I think, that's at work here, that the dog toy is treading into a domain that is felt to belong to Jack Daniels, and there's some free riding going on the effort of Jack Daniels to make themselves have a powerful mark. And so to this, I would just say, if 5 minutes left, I can start to argue a little bit, maybe I have all along, is that it's one thing to say Jack Daniels controls this, a t-shirt that has a pure reproduction of the Jack Daniels mark. It doesn't destroy the billions and billions of dollars, right? That's what the attorney is talking about. Merchandising is really lucrative. It's a big part of the income of famous brands. And you don't actually endanger Jack Daniels' right to control this if you say that there's something expressive about that. And that kind of gets me to my final point, which is not really supported by any particular exchange in the argument, but just by way of conclusion, right, is that this kind of fundamental question of this case, I think, is, how powerful do we want brands to be, right? How far are we going to let our intuitions of dessert run in favor of letting made-up objects dictate what we can or can't say or buy or purchase in public? I mean, we're talking in Jack Daniels about giving the brand an insulation that no famous person has. You are free to make poop jokes about Donald Trump. You are free to make poop jokes about Joe Biden. You're free to make much more vulgar jokes about either or whatever political figure you care for. And the reason why someone's making the poop joke about Jack Daniels is that Jack Daniels is famous and they worked really hard to be. And they've shoved their brand in front of our face. It planted it into our subconscious. And so when we make art, when we make commentary, we're going to do it about the stuff that we find in everyday life. And brands are some of the things that we find in everyday life. And so there's an idea that, oh, this somehow causes them harm. Well, not really, because the only reason they're being mocked like this is because they're so powerful in the first place. Congratulations, you're in the big leagues. People make fun of you. Some people might make a buck off of that. And it's probably not even that harmful, right? To go to the Barbie girl case I talked about before, it was the subject of heavy litigation with Mattel. Mattel said, the heavens are going to fall if someone can just go ahead and make a song parodying Barbie like this. They played in the clubs. There's drugs in the club. You take ecstasy and listen to Barbie girl and go all night or whatever. And then Mattel loses, and Barbie, there's a movie coming out, and a couple of years later, Mattel licenses the song so they can use it in their, some celebration or some anniversary of Barbie. Turned out it wasn't so bad after all. Okay, so I'll conclude there. I guess I've reached the point where if you're here for CLE, you've probably got it, but I'm happy to answer questions as long as people like. Yeah, Mr. Brayden.
Would it have made a difference if Jack Daniels had a similar chew toy prior to them creating it, or is that entirely irrelevant?
I mean, it clearly would be relevant to litigation because it would make the claims of source-like confusion or intruding on their market look a little more look a little more plausible. From my perspective, it shouldn't make a difference, right? But again, I mean, we have to talk about when we're talking about merchandising, right? I'm wrong, quote unquote, right? I'm legally wrong, right? In this case, this is something courts will protect on affiliation approval theories, and so your hypothetical would only strengthen that kind of claim. Room, yeah.
Has Jack Daniels always been this litigious? Because seeing the two bottles side by side, they really aren't that similar. It's like I've seen other dog chew toys and other cat toys that have like that sort of parody element, like the Wolf Street Journal. Mm-hmm. And it's not like they call it Bad Spaniel. It's not like they called it Jack Russell. Right.
Yeah. I don't know about earlier Jack Daniels cases, so I just don't know the answer to that question. I would say that there is an interesting question about what makes people decide that this is infringing, right? And so I think that, as I said before, like the tail that's wagging the dog, I think, is that this is copying, this is free riding in a market that properly belongs to Jack Daniels. So full stop. It's possible though, right, that maybe the court really is disposed to look for differences. And here's where something that I think that's kind of interesting is this, the use of the multi-factor test. That, I'd love to conduct an experiment on this, that if you show 100 people and say, here's these two, is there a connection? Are you confused? Versus show the same 100 people and say, are you confused? But let's think about it this way. Let's ask, how similar are the marks? Let's ask, how strong is the Jack Daniels mark? Let's ask, how close in the market are these two things? And so what I'm doing, for those who don't know it, I'm running through some of the Polaroid factors of this multi-factor test. And there is this interesting question, if you structure the inquiry in a particular way, maybe one good thing is that you think about the things you ought to think about, but maybe there's something biasing about the way the inquiry is undertaken. And so, which is not part of your question, but something I thought of, so I felt like saying it. Yeah.
Did you say that dilution was not an issue in this case?
No, it's still live. I
okay.
just ignored it for time.
Okay.
Yeah. So, and the parties didn't talk about it nearly as much in the oral argument. But the question is the scope. So in the dilution statute, there is an exclusion for quote unquote non-commercial uses. And the Ninth Circuit in the Barbie Girl case said, look, obviously Barbie Girl has a commercial aspect in the sense that it's the title of the song, but also has a non-commercial aspect in the sense that it's the song, right? And it's part of the song, and it's okay to describe the content of the song. And when you have this kind of mixing between commercial and non-commercial, tie goes to non-commercial and First Amendment interests. And so the non-commercial exclusion was read to cover, so that precedent makes the non-commercial exclusion cover the Jack Daniels chew toy, the Bad Spaniels chew toy. Cert is granted on that, and so that's also up for grabs. And it raises these interesting First Amendment questions about, to what extent does something have to be commercial, or what level of protection comes to things that are commercial in First Amendment analyses. And so there's a great amicus brief by Rebecca Tushnet where she makes the point saying that, from a certain point of, not just from a certain point of view, the dilution statute just ought to be unconstitutional because it's not about deceived consumers. It's about, don't say things that tarnish. Well, tarnishment is viewpoint to some extent. Sorry, I'm running with your question. So it does get engaged, but the main focus has been on the Rogers stuff.
You didn't cover the defense lawyer's case at all during your talk. What do you think was, excuse me, what do you think was the defense's most powerful argument or point?
At the beginning, there was a really nice statement kind of about the idea, kind of similar to what I was sort of saying at the end, that people get to talk about brands and it shouldn't be against the law. I mean, I'm butchering what he actually said, but he opened his statement with a very strong statement about the need for people to be able to talk about the things we interact with in everyday society. That's the main thing that comes to mind. I mean, but remember, they're the ones playing defense, right? And so that's yeah.
It seems to me like that Chewy Vuitton case
Yes.
wasn't brought up as often as I would think it would have been, considering that they were both dog toys.
Right.
And that was fine. And I know that the Jack Daniels lawyer says that in that case, the judge in their case, in the Chewy Vuitton case, immediately was struck by how different the marks were, but in this case, the judge was struck by how similar the marks are.
Right.
And to me, that seems like saying the same thing.
Saying the same thing.
Words.
Yeah. So for those who don't know, Chewy Vuitton is a case from the Fourth Circuit in which somebody makes a chew toy called Chewy Vuitton, and Louis Vuitton brings suit. And the thing about the Chewy Vuitton case is that Rogers is not applied. The court just simply applies the multi-factor test, but says, okay, as we do the multi-factor test, we're going to take into account that this is a parody. And so there's more litigation that goes on. And so from the perspective of Jack Daniels saying, like, that's great. That's what you should do, right? If you really have something that's non-confusing, and if the reason it's non-confusing is because you have a parody or some other expressive use, you'll win. It'll be fine. And in this case, though, the pushback from Justice Kagan and Justice Sotomayor is that, no, that's a cost, right? If you decide to make a chew toy that you know you're going to win on likelihood of confusion, but you get the C and D from Louis Vuitton or Jack Daniels, are you really going to spend what it takes to fight it out? But, and so in a weird way, Chewy Vuitton, even though it favors the parodist, is not necessarily, kind of provides help and pain for both sides, right? It shows how far some of these claims can go, but it also shows a defendant winning without having to bring in the Rogers test. Any questions online or?
No questions online.
Okay, great. Well, thanks for coming. And